And now, without any further delay, let's begin today's event. I would like to introduce your presenter for today, and that is Gary Bossert. Gary, you have the floor.
Great. Thank you, Alicia. This is Gary Bossert. I work on the Medical Society Plan and probably have met or talked to many of you on the call today. Thank you again for attending, and good morning. This is another Medical Society Plan Employment Law webinar. This is one of a quarterly series of webinars we present exclusively to Medical Society Plan practices. We select topics not specifically related to employee benefits, yet relevant to your work. I know that you fill many roles in your practice, and though titles can vary, one thing is common. You have some responsibility for the management of the staff in your practice and the recruiting process. Hiring talented individuals is critical to an organization's success, but in order to hire the most talented, you must first recruit them. Recruiting employees can be a challenging task, especially in the field of healthcare. With unemployment at historic lows, it can be difficult to fill certain types of jobs, so managers have to make important decisions. The unemployment rate has hit a low of 3.8%, the lowest it's been since 2000, which means it's harder to find candidates to hire. According to a study by the Society for Human Resource Management, 68% of human resources professionals say the current talent market is challenging, and one-half of organizations report that competition from other employers is holding them back. Hiring decisions are among the most important decisions made in any organization. Good hiring and onboarding practices can eliminate or reduce many legal risks, reduce costs, increase productivity, and improve morale. Ill-advised hiring decisions, on the other hand, can result in turnover, duplicative training, missed opportunities, and lost business. In addition, an ill-advised hire might well lead to employee termination, and every termination, no matter how justifiable and well-documented, exposes the practice to the risk of wrongful termination lawsuit or a discrimination claim. For all these reasons, it pays to take the time to find the right person for the job using the right process the first time around. We are fortunate to have Ann Murray and Lauren Nations from the law firm Nelson Mullins with us today to discuss how practices should recruit, hire, and onboard new employees to better protect you from potential liability. Ann is a partner in Nelson Mullins' Atlanta office, where she practices in the areas of employee benefits and executive compensation. She is a member of her firm's healthcare team, which focuses on providing comprehensive services to hospitals, physician practices, and other healthcare providers. Ann assists her clients with all types of HR and benefits-related matters, including those relating to qualified retirement plans and health benefits. She is a regular speaker and writer on various topics, including the ACA, HIPAA and data breaches, and on-site clinics. Lauren is a member of Nelson Mullins' tax and benefits team and assists clients with all types of employee benefits, executive compensation, and employment law matters. Prior to earning her law degree, Lauren worked as an HR professional, which allows her to better understand the challenges faced by clients in dealing with employment and benefits issues. Thank you, Ann and Lauren, for participating today. The line is yours.
Thanks, Gary. This is Ann Murray, and thank you, everyone, for joining us today. As Gary already highlighted, there's a lot of advantages, certainly, to everyone in handling your onboarding of employees and your hiring practices correctly. I mean, right now, the healthcare industry, as well as other industries, I mean, as Gary highlighted, it's a tough market out there, and you need people to be efficient, productive, make sure that your morale stays high, and you want people to stick around, those that can really help your organization. We've all seen the statistics on what it costs to onboard an employee and train an employee before they become, in a sense, profitable for you. So it's more important than ever in this market to do things smartly. There's problems that can be created by bad hiring practices, and certainly, the lack of qualified workers within your organization. But it only takes, we've all been through the experience on the HR side, where it only takes one bad egg to create or take down your employee morale. It's amazing just within a department or a division of your organization how things can go south real quick. And that creates workplace disruption. We can see high employee turnover if people are not happy and you're bringing in the wrong folks or communicating the wrong things to your new hires as you bring them in. And then certainly low production and efficiency. We've all dealt with that. And legal liability. That's our worst case scenario. And that's certainly one of the things that we're going to focus on today is trying to avoid things that can create potential for legal liability for you. And some of the areas where that legal liability can come up are, your application forms. I mean, there's a simple one. Start with that in making sure that your hiring is proceeding correctly. Interviews, that's always a tough one because you may not always be present when the interview is happening, but there's certainly some takeaways that would be good for you to communicate to your team and those in management who might be conducting the interviews. Background checks and FCRA, drug testing, and we're going to focus in particular on North Carolina rules, and then employee benefits waiting periods. In a tough market where you're trying to bring people over maybe from another physician practice or some other competitor, there is that tendency to want to waive waiting periods. Well, we'll get you some medical coverage quick, or we'll get this or that. And so we'll talk about some of the pitfalls or potential gotchas in that area as well. So let's first move to application forms, and I'm going to turn it over to Lauren to talk about this.
Good morning, everyone. So obviously the application forms has some pros and some cons. Obviously, the benefit of having the application form is this is going to be your opportunity to get some initial information from the applicant about their education, their experience, and their job skills. But you want to always keep in mind that many applications that you may find on the internet or that you may have inherited from your predecessor, they may contain questions of doubtful legality, especially with the changing employment laws that protect different classes of applicants and employees.
And, that's a good point, Lauren. I see that a lot and talk to a lot of clients who, there's an incredible amount of information available on the internet. And we all hear the don't trust what you get. I mean, I've seen plenty of really good forms and things that are available, for free out there. But you're right. There's also a lot that I think are outdated and have just kind of carried over, or are from a state where something's permitted, whereas it's not permissible in your state or locality. So I think that's a big trick.
Exactly.
Or a big gotcha.
So the best thing to focus on is keep it simple, like Ann said earlier. What do you really need to get from the applicant at this stage of the process? You want to get their full name. You want their address and their telephone number so that you can contact them if you want to follow up on the application. Find out the type of work that they want to do. That's your first opportunity to make sure, does that even fit with the job we're posting? Maybe they've applied for the wrong one, or their expectations aren't quite in line with what our job is. Find out the date they're available. Maybe they can't start right away. That could be a problem for you if you need someone that's, to be there right away. Find out the salary that they're looking to obtain at this new job. And we'll put an asterisk next to this because notice how we said salary requested. We didn't put what was their salary history. And currently in North Carolina, that's not prohibited for an employer to ask about that. But there's a growing number of cities and states that do ban an employer from asking for an applicant's prior salary history. The reasoning for this is because, the EEOC has found that can continue to suppress an applicant's salary. So if he has to put on there, I made only $10 an hour, but this position you were going to pay $15. Well, now that you know he only made 10 before, you might be more likely to continue to only pay him 10. And if he's, in a protected class, the African American, or he's disabled, they would, tend to show that was impacting him in a bad way. That's
a great point, and I've seen that so many times among employers where they say, yeah, but we can get this guy or get this person for a deal. Why are we going to, and I've seen that come straight out of the HR department. And as Lauren says, you can certainly do that right now. Yeah. In and of itself, it's not going to be illegal. but it also just may be the wrong thing to communicate to employees on their way in.
Right.
It leaves them with a bit of a bad taste, especially if you have a lot of people in that same role at that same pay level where they may talk and may find out that they're not being paid the same amount.
And they will talk, as Ann and I have seen. So something else that you really need on the application is their education. You want to make sure they have any degrees that are required for the job, or the school experience background that you want them to have, and any other knowledge and experience they may have that applies to the job they're applying for.
Do you advise employers on the education side? We all hear these stories about the person that claims to have a degree and they have made it all up.
Right.
The statistics are there's always a few little white lies in everything, but the degree in and of itself. What about when they're submitting an application, providing some sort of a copy of the diploma or certification? I don't know. Do you hear people talk about that?
As in that they're requiring them to submit I think that's helpful, just because it gives you the ability to go ahead and see that they're being accurate. One thing we do recommend on these application forms, as you probably have seen on some of the samples out there, that right before, at the bottom, they sign certifying that all the information is accurate, because that then gives you the ability to point to a reason when you later find out they lied about their education, that you didn't hire them because of that. It wasn't for some discriminatory reason.
Yeah.
So we do recommend you have that certification statement in there.
And I think especially when you're on the medical side of things, as most of our attendees are today, if you're looking for one of those positions where someone legally has to be licensed, I think it's really important that some sort of additional a copy of your license or certification is obtained, because that's just going to serve to protect you if the worst case scenario happens and someone turns out not to have that license.
And then as far as the references, we usually recommend maybe 1 or 2 professional references and maybe 1 or 2 personal references. Just know that to the extent the personal references are used, that could trigger some obligations under the Fair Credit Reporting Act, which we'll talk about later. We've provided a sample employment application. This one pretty much keeps it simple. So just like we recommended, feel free to use that one. It's been screened and approved by Ann and me. So avoiding application pitfalls, mainly in any location that you're in, whether you're in North Carolina or any other state, if you have locations across the U.S., you want to review the applicable employment practice laws. So, for example, North Carolina, as many of you probably already know, has several statutes that are impacted by an application, such as, the Equal Employment Practice Act. They also have a lawful use of product statute, which, you can't refuse to hire a prospective employee who's engaged in the lawful use of lawful products during non-work hours if such use doesn't adversely affect that person on the job. North Carolina also has the Genetic Information Discrimination Law, which protects applicants with sickle cell trait or hemoglobin C trait. So there's just things that you want to be careful not to ask about on the application, or more likely during an interview, which we'll talk about next, because you don't want to trigger any claims under those employment practices laws.
Okay, let's move to the interview process.
All right. So go ahead, Ann.
Certainly the purpose of your interview, should be taking what was in the application, and as we've advised, keep the application simple, but taking that and now building on it. What more information do you need, and building off of their answers on the application about their work history, what have they done that's similar in the past?
Mm-hmm.
What in particular is crucial to your operations for you to find out about? But, all that being said, there's a lot of do's and don'ts and things to consider when you're coming up with your questions.
And we've included a sample job description, or is that what this is?
Interview process.
Interview process policy here. And you'll notice that one of the things on there, I believe, talks about a job description. All qualified candidates should be interviewed using the guidelines established for that position. This is also a good opportunity to make sure that you have job descriptions for your positions that you're hiring for. That will help you and your other employees in your department that are conducting these interviews make sure that the applicant is qualified for the job. Instead of most people, they think they know what someone does. This way they'll know for sure these are the qualities that we're looking for.
And I think it's really important. A takeaway on this is, make sure that the actual people who are going to be interviewing, if your practice is, if your procedure is to have the applicant or the interviewee interview with 2 or 3 different people in your organization, make sure every one of those people has received a copy of the job description. I mean, I can't tell you how many times I've seen folks come in and the person interviewing them doesn't even really know what the job is that they're in. They have an idea. Oh, yeah, we need a new file person, or we need a new, nurse for this position. But what is it they're going to be doing day in and day out?
Well, that's why you'll notice that some of these practices, they may have like a manager of that person, who's going to be the manager of that person. They will interview. And that's good because, they're kind of the higher level person who's going to make an evaluation of the candidate. But that manager may have been that junior level person so long ago, or the job may have changed so much that he doesn't really know what that person's doing day to day. So sometimes, you'll see these procedures that they'll have another junior person interview, not only that person, but along with the manager, separate from the manager, which will also be helpful to give the candidate the opportunity to ask questions, about the person who's actually doing that job. What is it like? What do I need to know? Or
what about providing almost planted questions to the people that are going to be doing the interview? As the HR person, is that something that, have you seen people do it, or would you recommend it?
When I was in HR and interviewed candidates, we did that mainly because it's going to make sure you ask the same questions of all your applicants. I mean, granted, if this candidate has a unique experience or he made an answer that gave rise to another question, you can deviate from that. But I think we mentioned that later in one of the interview do's and don'ts, like stick to the script to the extent you can, because it's going to make sure that you treat everyone the same. You don't want to be asking tougher questions of certain candidates than others because, again, they may say, oh, well, that was because I was this protected class that you were.
And you definitely don't want to go into the questions you can't answer.
Right. We'll get to those, too, because we do include some of those, some questions that people have asked. So like we have on this slide, do determine whether they have the basic qualifications, interests, skills, traits, and motives required for successful performance in the position. And that's the good thing about the interview, like Ann said, is it allows you to go beyond the application and actually talk to this person and see if you think they're going to be a good fit. Even is their personality going to fit the department. And the interviews also, weed out disinterested applicants so that you can describe the job. Like Ann said, this helps them not to have an unrealistic expectation of, what's going to be required of them, and maybe they may self-select out.
Yeah.
Or you can know, hey, they're not quite going to be a good fit.
And in a sense, that's hard to take sometimes, but isn't it better to know before the person takes the job that they're not the right person, that the job is not right for them, than spending the time and money afterwards? Because I think it's similar. What I see is it's very similar to, quite frankly, when people do the performance reviews. You get those people who will give all fives, on a scale of 1 to 5. Everything's excellent, even though they're frustrated with the worker and things weren't perfect, just because they want them to like them. And it's similar on the way in. How many times do you see people who are interviewing and they oversell the company? It's a sales pitch, not a realistic pitch. And I'm not saying tell them bad things about the company, but I'm saying, if this requires overtime work and you need to get work done, if we need you to stay 2 extra hours, that's going to be expected with no notice. Make that clear. Don't give them the idea that you can come and go as you please and, it'll all be up to you, because that's just you're going to get the wrong person.
Right. And you have to remember, too, that these candidates are putting their best self forward during these interviews. So if at that point when you're interviewing them, you're kind of having some second thoughts, listen to those thoughts. Don't just say, oh, well, I'm sure if I give him enough training, he'll come around, or, it's like when you're in a relationship. People don't change. When you're in a personal relationship, it's similar with employees too. So, as much as you hope for them to. Don't prejudge. So even though you may have an initial impression about someone, that's not to say to not give them, the benefit of the doubt, or to look further for qualities they may have that will be a good fit for the job. You may be surprised at what you find out, from people once you give them a little bit more opportunity to describe certain situations or that they've been through. This is a big one. Don't ask questions that are prohibited. If it's off limits on an application, it's still off limits during an interview. You're still not allowed to ask questions that you wouldn't be allowed to ask on an application. I think we've actually got some samples of those, in a later slide. And along with this, don't deviate too far from the prepared and approved script. Again, you want to show that you've been treating your applicants the same.
And that goes back to the, if you're having a number of people who aren't experienced on the HR side conduct the interviews, you may want to just come up with a general list of questions.
Yeah.
They may be appreciative.
Right.
I mean, quite frankly, especially if they don't have much time in their day to prepare,
right.
They may just appreciate having kind of a script to go by.
Yeah. So here are some problem inquiries that we've seen come up. What is your date of birth? Because that's going to trigger, at this stage, you will eventually need that whenever they are onboarding for their benefits or whatever for your payroll system. But at the application interview stage, you don't need to know how old they are. I mean, it's just going to present a risk for them to say, well, it was because I was over 40 that you didn't give me this job. You're only hiring younger people. So if you don't have that, that takes care of that.
And counsel your people that we put this on here as a direct inquiry, but there's a lot of indirect ways of going about that. When did you graduate? Can still achieve the same end goal of estimating right how old someone is. So you just want to steer away from things that are tied to certain time periods.
Exactly. Like you can find out that information if you're trying to figure out how much work experience they have. That's different because that's not necessarily tied to age. But you do have to be careful there. It's not just their date of birth. That's a good point, Ann. Do you have any disabilities or impairments? That one seems pretty standard that you would know not to ask that. But again, what you need to ask is, are they able to perform the job with or without a reasonable accommodation? And even in North Carolina, I noted that you can't even ask them, they can't be required to identify that they are a person with a disability prior to a conditional offer of employment. So at this stage in the interview, you haven't extended that offer yet. So just try to really stay away from questions that ask about disabilities.
Now, what if you have a person in front of you that appears to have an issue? I mean, I guess that's going to be your point where you want to make a point of saying, are you able to do this job? But you can't really go much further.
Right. Not until they actually, and then you can, and when I say conditional offer of employment, you can then make their offer contingent on their ability to perform the job and going through that dialogue of what is a reasonable accommodation and will that be an undue burden, et cetera. But you can just basically ask them, are they able to perform the job? And that's why it's also helpful to give them that job description and during the interview process to describe the jobs that they can then hopefully honestly make that evaluation of themselves. But at that point, that's all you can do. Are you a U.S. citizen? That one, sometimes most people don't think that that's an improper question to ask, but I think it's because most people don't understand that you don't have to just be a U.S. citizen to work in a U.S. company. As long as they're legally authorized to work in the United States, a non-U.S. citizen would be able to do the job. So that's what you would rather ask is instead, do you have proper work authorization to work in the U.S.? Are you married? That one probably doesn't come up as often as it used to in the past, in the olden days.
Right.
But
remember
it may still.
Don't wear your wedding ring to an interview recommendations.
But now, that one, I think, and that one seems innocent, maybe sometimes when you're asking, just trying to get to know them better. And that's what I think happens. Sometimes people get too comfortable during the interview process, asking questions like that. So just be aware that that could trigger, some marital status and sexual orientation laws.
Now, what happens if the person starts mentioning their spouse? The tendency we all have is to get into that conversation.
Yeah.
And now you could start spiraling sort of in the wrong direction. I mean, granted, they've brought it up.
Right.
but I think you still need to be careful not to kind of follow that with, oh, you know, do you have a family?
Right.
You know,
what are your child care responsibilities? Is that going to impact?
Right.
You know, you just have to stick with the script, like we said earlier.
I think we skipped over, have you ever been arrested?
Oh, yes, and that's an important one. Sorry, Ann, thank you. Because, I mean, most of you in HR, you are aware that there's more and more states that are adopting ban-the-box laws, and also that could impact some Title VII categories. So just stay up to date with those. It's just better not to ask at this point. Save that for when you then move on to the background check and you're doing a criminal record check.
And we'll talk about that in a couple minutes.
In a couple minutes. But North Carolina currently doesn't have a ban-the-box law. But again, it doesn't mean that it's changing all the time. So it doesn't mean that they won't in the future.
Yeah, in fact, I heard recently in the news that some of these states that have legalized, you know, marijuana and other substances, I believe it was California, and don't quote me on this, but I mean, some of them are taking the step of actually going and sort of expunging all these prior arrests that people had for use and possession, going back. I mean, you think about what that does for someone's life, but it's going to make a difference on background checks and when we get to that.
Exactly. How many days were you sick last year? Again, it seems innocent. I mean, kind of. I mean, I don't think anyone would come out and ask that question because it doesn't seem appropriate at all.
Never say never.
I know, right? Someone has. That's why it's come up. And then do you have children? What country are you from? Again, these seem kind of like, oh, I just want to get to know this person. They have an accent. So what country are they from, right? Seems innocent. Well, maybe not at this point. What is your prior workers' compensation history?
That's a loaded question.
I mean, yeah. I mean, as an employer, you would love to know that, but that's not a proper interview question. And then how much do you currently earn? That's what we were talking about earlier, that using desired salary is going to be safer than asking about what they earned at their prior job.
Yeah. And even, you know, in the end, you generally know what you're going to be paying for a position.
And you should pay
it,
you know.
Right. That's kind of my view on that.
Yeah.
Okay, background checks and the FCRA.
This is probably one of the more important pieces of this presentation. So if you've fallen asleep for a little while, wake up and now take some notes. Mainly because this is where there is some liability and there can be some significant penalties if you don't follow the steps that the Fair Credit Reporting Act has laid out. So we have a link here to this joint publication from the EEOC, which, as you know, administers all the federal equal employment laws, and the FTC, who administers the Fair Credit Reporting Act. They have a pretty helpful guidance on, you know, what you need to know and the steps you need to take when you are conducting these background checks. And so if you copy and paste that link, it should take you right to that publication. So basically, when you use a background check to make an employment decision, you have to comply with federal laws that protect applicants from discrimination. And the FCRA is impacted when you run a background check through a third-party company. So you go online, you use a service from someone else to run this background check. That's when you're going to have to follow the FCRA requirements. So one important thing to note about background checks is to actually make an intelligent decision, you want the information to be actionable and accurate. And a lot of this comes from the report being accurate. Not all criminal records are updated. Sometimes, like Ann was saying, sometimes they go back and they get expunged.
Yeah.
And, there's not even a central location for someone to access someone's all U.S. criminal records. So these can present challenges in trying to use these criminal history records to make an actionable decision.
Now, don't get us wrong. It doesn't mean you don't want to get a background check, and especially, let's face it, in your businesses where you're dealing personally with so many, patients and clients, heaven help us, if something happens, you want to make sure that from the employer perspective, you can show that while we all understand it's not a perfect process, you at least went through the process and acted reasonably with the information that you were able to obtain. I think it's kind of a two-edged sword,
So this is what we were saying earlier, is that, there's no national database that's available to you as an employer to check criminal records like there is for education or such as education or employment. So you may have some that are false positives. You may have some that are false negatives. And there's nothing really that is in place to update most commercial databases with subsequent history. So, if you run a record check online for someone, it may have some information that's not even accurate or not updated.
And this is where it's important that as part of the background check process, whoever in your HR department is handling the background checks and doing the requests, they should have the application for that person in hand at the time that they're requesting the background check, because that's going to give you a roadmap. There is no national database. So when you're requesting the background check, are you just requesting it for North Carolina, or do you need to go into other states? Are you going to pay for 50 states to be checked? Probably not. On the other hand, if you know that someone just spent the last decade in Florida, well then, it's going to be expected of you that you have checked Florida to see whether or not there were any types of complaints.
Right.
So I think that's where, the application, or if you've received a resume from the person, that it's important that you're checking both.
Yeah, exactly. So this slide is in respect to, when you as a private employer go online and do a search for someone. The information, you have to just keep in mind that the only information you're going to be able to obtain is what's public record. Right. So you may not find everything. So just keep that in mind.
And even if you find something that is a positive, or indicates that someone has an issue, as we'll talk about in a few minutes, you're still going to need to do further diligence, because just because the internet says it is so, as we've all found, doesn't necessarily. Right. Yeah, Google is not always right. Don't quote me on that. But.
So looking where to search, you have to, like Ann was saying, select counties to search in. You can't search everywhere, so just try based on the application or the resume or the interview that you're paying attention to where you need to expand your search. So we recommend the best protection is a 7-year county search of where they've lived, worked, or studied based on a social trace.
Yeah, and so don't forget wherever they went to get their degree.
Yeah.
That they were probably living on campus and living in that location.
Yeah. And people are so mobile now. Your search is more than likely not going to be just for your local area. There's very few people that have, been born and raised and now work in the same area.
Yeah.
And as far as how far back you should go, under the federal FCRA, you can go back, as far as you want to for convictions. But there are some states that have a 7-year rule, so that seems to be a good, time limit.
And that's whether you do it yourself or are using a third-party service. Yeah, in general, 7 years, what I see most people do.
And I think 7 years is plenty long enough when you think about how, people who maybe in their early 20s or late teens had some wild times or whatever, and now, you think about how 7 years from that is a good period of time to where they've matured and, can explain certain things that may have come up from when they were younger. So that's probably a good relevant time period, too. So these are just some other, certain things that you need to consider whenever you're looking at these background checks. Maybe their adjudication was delayed or deferred.
And that's important. If you see something in the background check that refers to, a conviction, you're going to want to investigate further with the applicant. Just because a background check comes up with a hit, a positive, doesn't necessarily mean that in the state in question, the person really did something during the 7-year time period, let's say, if that's what you're going back to. There's delayed adjudication, there's deferred adjudication, there's all sorts of, depending on the state, the county, there may be different rules that you're not as familiar with that may be behind the reason that this is coming up positive. And conversely, it may also mean that you could do a background check, and unfortunately, someone may have one of these delayed adjudication or deferred adjudication, which basically means that the judgment and perhaps the trial are going to be delayed for in some cases, it could even be years. You may not even have a hit for whatever they've done, and
Sure.
after you've hired them, all of a sudden it gets entered. So, you see that with DUIs.
Yeah.
It's not unusual for a DUI conviction to not occur in some states for a year or more after the actual, quote, crime,
Right.
occurred. So it's not perfect.
Right.
Don't expect that just because you ran a background check, everything is going to come up.
Yeah. And I think that's actually better now that the market in a lot of positions that are open is somewhat dry, because you think back to when people were hiring a lot after the recession, there were so many candidates out there. And so you wanted to just be able to use certain preliminary methods like the application, like they didn't fill something out right or whatever, to screen people out. Be like, oh, let's put that in the pile that we're not going to call them. But now I feel like that there's less qualified candidates out there. You can take that time to, like Ann said, give this individual attention to some of these reports and think about, whether you want to, discuss that with the applicant.
Yep.
So again, this is just, some legal concerns from getting these background checks. I mean, like Ann was saying, especially in the healthcare practice, you always have the concern that I don't want to have a negligent hiring claim. I mean, especially in the medical practice, this is a big deal. You want to minimize risks for violence and drugs and theft in the workplace. As an employer, you have a general duty to maintain a safe workplace. Is this person going to abide by those safe workplace policies? So those are definitely legitimate concerns as to why, like we said, we're not saying you don't want to get these background checks, and in some cases you're required to. But you just have to keep in mind that there's legal risks on the other side, as there always is. EEO, any state laws that restrict the use of your criminal history, and again, the big one with the FCRA compliance, which we'll talk about next. Those are things you have to keep in mind that you have to comply with. So just make sure that if you have any blanket restrictions or exclusions based on criminal record, that's going to leave you open to major exposure by the EEOC. As we were saying earlier, the reason why these ban-the-box laws have come out is because the EEOC has found that people who generally have criminal records are in protected classes, minorities, and that they're disproportionately being impacted by an employer saying, well, I'm just not going to hire any criminals, forget it, even though that person may have rehabbed and or it may have been a wrong charge that's brought against him.
So do you find that instead of the blanket exclusion, if it's more directed, let's say, for example, since we're talking about the medical field here, if this is a position that's going to have access to controlled substances, well then most certainly I think we can say that it will be reasonable to have a restriction or an exclusion for those who have prior histories of drug sales or anything of that nature.
Right.
But if that same person has a criminal history, I don't know, I'm trying to think of even an example that would come up, but, let's say as a teen they, had a burglary or a theft or something like that. Does that mean they're now going to be the person who, it's a tough...
That's why I think you want to make it individualized to the job. Like, what is the business need for why a person with this particular past shouldn't do this job? And it's like you said, if they have a history of drug use or drug abuse, that makes perfect sense, but if they stole a watch, when they were young from a store, is that, going to...
And I can come up in my mind with, well, if they
stole that,
then,
exactly.
But I think you have to take that step back and kind of act reasonably in trying to tie together does it make sense that the reason I'm excluding this person, does it really pose a realistic risk?
Right.
To my customers, my patients, my organization.
Right. Like if the person's going to be a file clerk, it's not going to matter as much, because he doesn't have access to those controlled substances, for example.
Correct. Okay, let's move on to FCRA.
So the FCRA, as we mentioned earlier, anytime that you're involving what they call a consumer reporting agency, a third party to pull this background check, including credit payment records, driving records, criminal histories, you're going to have to follow certain steps, and failure to comply with those can subject you to liability. So before you, there's like several steps that you go through when you're obtaining a background check through a CRA. Before you obtain the credit report, you need to notify the applicant. There's two requirements. There's a disclosure requirement to the employee that you make, and then there's a written authorization requirement that comes from the employee.
And that's included in that sample application form
yes.
that is at the earlier in our presentation.
Okay. Yeah, and it can. So for the written authorization, you can actually include that in your employment application. We recommend that you generally have that in bold, large letters so that the employee can know they are, by signing, authorizing you to pull this report. As far as the disclosure, though, you can't include that in the application. That has to be a separate form. You can combine that with the authorization, but the form can't contain anything other than the disclosure that you're going to be obtaining this report for employment purposes. And then when you then request the report from the credit reporting agency, you have to make certain certifications to the agency that you're going to be complying with the Act. And that you won't use the information to violate any equal employment opportunity laws. The CRA is going to prepare that certification generally for you so that you can then just certify that you'll use it the way you're supposed to. Before you actually rely on the credit report and take an adverse action to reject an applicant, you have to provide them with the first and the last bullet with a copy of their report and a summary of their rights. You also need to let them know that you plan to take an adverse action based on the report. And it's also recommended that you wait a reasonable time before you actually take that action so that they can then, give you some feedback on maybe explaining what has come up in the report. We generally recommend about 5 business days. And then, but when you actually take the adverse action after that time period has passed, you provide them with the 3 bullet points in the middle, a notice containing the name, the phone number of the agency. That way they can contact the agency and see about updating the information. The statement from the agency that they didn't make the decision because the agency wants to be protected. They're like, hey, we didn't make the decision not to hire you. It was the employer.
Right.
You have to let them know, the employee know that, or the applicant know that. And then you have to provide them with the ability to, their right to dispute the accuracy or completeness and to request an additional report from the agency within 60 days. I know we're getting close kind of toward the end of our presentation, so we'll run through drug testing pretty quickly just because it's pretty straightforward based on the North Carolina law on this. It's the North Carolina Controlled Substance Examination Regulation, if you want to look it up.
And I think it's clear there's no duty.
Right.
I mean, nobody has to conduct drug testing, but once again, we're in the medical field here.
Right.
And especially for those positions who are going to be coming into contact with controlled substances, for those positions in particular, I think it's going to be important for liability purposes to make sure you drug test.
Yes, for sure. So you don't have to do it, but if you do, you want to make sure that you're complying with the regulation. These are just basic scientific requirements. You're using a single-use test device. And then if the test is positive, the lab must confirm their result, and they have to use the gas chromatography with mass spectrometry. You guys are probably more familiar with what those are than us as attorneys are, or an equivalent scientifically accepted method unless the applicant waives that.
So it's important because, I guess this brings up the question, we do have a lot of medical practices. Well, why can't I just do it in-house? Should I use a third party? I think first and foremost, if you're hiring a third party to do this for you, which I think is what the majority of people do, and is, I would say, my recommended approach. I don't think, you don't want to DIY it. But if you are using a third party, you want to make sure that since you are bound by North Carolina rules, that they're complying with those rules, especially if it's any type of, even if there's the mail away type of scenarios.
Sure.
Or if you are close to state lines.
Yes.
And someone might go to a facility that's over state lines, did they comply?
And to the extent that you have offices outside of North Carolina, I mean, different states have different requirements. I believe most of them are similar to this, at least here in Georgia. I think it's the exact same requirement. But you just want to always make sure, just like we were talking about with the interview questions, that you check the local regulations to make sure you're complying. It's also required that you provide the applicant with written notice of their rights. These lawmakers love to make sure the applicants are informed of their rights under all these different laws, and that within 30 days from getting the results that you notify them in writing of any positive test result and their ability to retest. What I was going to mention here, specific to North Carolina, is that you guys probably know this, that they permit the use of hemp, the state permits the use of hemp extract in treatment of intractable epilepsy. So just make sure if you're screening for any, marijuana products, that if that comes back, you may want to follow up, again, to the extent you can, with any ADA sensitivity there, that to see if they have a medical condition that requires that, to explain that, I'm allowed to have this. I'm not just someone who doesn't have a condition that needs it.
But in this day and age, it brings up the point of, what do you do when the person's come in and their drug test comes back positive, let's say for marijuana, and, well, they just got back from a trip to Colorado. you
right.
know? I mean,
well, and again, that goes back to, because North Carolina is one of those unique states that they have that lawful use of lawful products and non-working hours. So that's another, the whole thing with marijuana has really made it interesting, and you have to stay on your toes and come up with creative ways, and always be checking with your counsel on, how should I address this?
Yes. So my point would be, I think it's very important. We're not going one way or the other in our discussion here,
right.
But if you do have someone come back with a positive and their response is, for example, I just got back from Colorado and it's legal there and I was using, I think that's one where you do need to reach out to your legal counsel and make sure that you're approaching it properly, given North Carolina's
because,
law.
that statute not only protects employees. So at some point you might think, oh, well, they're not an employee to be able to use that. It also protects prospective employees, that you can't reject them for their lawful use of lawful products. So, it's been expanded to include situations like that where you may want to exclude someone who had a positive marijuana drug test.
Yeah. Well, that's a changing world. Employee benefits waiting periods. So as I said, especially as it's become more and more difficult for all of us to recruit lateral hires and new hires, there is a tendency to agree to waive waiting periods and to put in place, special provisions because the applicant or prospect is demanding it. My point here is, as a general rule, it's not a good idea to agree to waive any types of waiting periods for items such as medical coverage. There are better approaches. If you have someone who's coming to you and saying, I need coverage immediately, I'm on COBRA from my prior employer, it's better for you to just say, I will, if you're looking to really get this person, it's better for you to say, I will cover the cost of your COBRA or help you with your COBRA than for you to do something within your system or processes to make an exception and put them in. If you have a normal 90-day wait, you don't want to be waiving that for certain people coming in because, first off, it could create issues with the plan, and we're all here, with the same plan that you're using, and so that can put you into jeopardy with the rules under the plan. But it also can put you into jeopardy with the IRS rules relating to discrimination. And so it's just important that there's better alternatives. Just pay for part of their COBRA coverage and keeps it a lot cleaner. As far as waiting periods go, you need to be aware that 90 days is the maximum waiting period that any employer, no matter what your size, is allowed to impose for medical coverage. If you are one of these people that in practice has been making people wait. Sure, you're only requiring 90 days, but you don't really enroll them until the first of the following month because from an administrative perspective, that's just easier to do. That violates the Affordable Care Act rules, and that can subject you to some significant penalties. So we strongly recommend that you cease that process and stick with the rules under the plan, and in all events, no matter what, getting people in within 90 days. Along the same lines with waiting periods, I think it's important for everyone who is a larger employer, and what I mean by that, an applicable large employer. So someone who has 50 or more full-time equivalents. If your organization is an applicable large employer, and note that's measured not only within your organization, but if you have related entities, all of you sort of get combined for purposes of counting these employee numbers. But what's really important is at the time that you hire someone, you need someone within your HR department or within your organization to be making a clear decision and consistently applying these decisions as to, is this a full-time person? For Affordable Care Act purposes, that's someone who works 30 or more hours per week, who is reasonably expected at the time you hire them to work 30 or more hours per week.
That's you have to. Point. People probably don't think.
Yeah.
You know what I mean?
It's a question that you have to ask yourself. Is this, and especially if you have multiple locations and different people might be handling the hiring process, you don't want it to be kind of willy-nilly depending on who was doing it. You want a decision made. Is this a true full-time person? If they're designated as a full-time person, then they got to come in the plan within that 90 days, if they're in an eligible group. And there's a possible 1-month orientation period that you can add to that. But if you're going to do that, make sure you work with your legal counsel to set it up properly. But if they're not, if you can honestly say, I don't know, you know what, it could be we may need them more, we may need them less, it's going to vary, then they can be called what we call variable hour. If you are designating someone as variable hour, then you need to make sure that you have the proper processes in place to measure their hours and to check back and see whether or not they have, after the first year of employment, averaged 30 hours or more, because that may entitle them to come into the medical plan. The point here is, on the hiring end, if you are at or above this 50 full-time equivalent level where you are treated as being subject to the Affordable Care Act, you need to make sure that you have these processes in place, because it can really end up costing you a lot in the end. I mean, example is, in fact, I worked with a company last week that, they had 70 employees, but they had not been tracking, whether or not people were truly full-time or had worked enough hours to be treated as full-time. So out of these 70 employees, they only had maybe in the high 40s for people who were truly full-time. But the rest of them, they weren't measuring their hours. They were never getting around to offering them medical coverage. Well, when we looked back at the numbers, it turned out that a lot of these people that weren't characterized as full-time, what we call variable hour, well, they'd had a really busy year, and they had worked a lot of hours. And what happened is those people sort of put them over the limit where they hadn't offered medical coverage to enough of their employees. And the problem there is the penalties that apply if you don't make those proper offers apply based on your total full-time employee population. And so, in their case, we were talking about a couple $100,000 a year in penalties that they owed for a handful of non-full-time, or variable hour employees that they hadn't tracked. And, it was just, it didn't even occur to them. But that's just something that, not to put the scare in people, but it's just something to think about that, that you need to be a lot of you are small employers and you don't have to worry about this, so thank your lucky stars.
Keep it small.
But it's important to note, this is also important for those of you who might be getting close to that 50 employee count. And when I say 50 employees, I'm saying, you could have 20 full-time employees and 40 part-time, and if their hours add up to enough, you might count as 50. So, if you're one of those that's getting close to this, kind of crossing this threshold of being subject to the Affordable Care Act, just make sure you talk with your outside benefits consultants or your attorneys if you have one that works in this area, and just make sure you've got things set up properly, because it can be quite expensive.
Well, it sounds like it's something you have to constantly monitor too, as your employees counts go, as you grow.
Yep. Certainly. Okay, so let's take a look at, we have a couple of questions that have come in, so I'm going to let Lauren, you want to take the first?
Yeah, so I think I only see one question, Gary, so let us know if there's others.
Sure.
But Carmen had asked, can you retract an offer after a background check if the criminal offense would not pose a problem to perform the job? For example, an accountant, but he has a DUI conviction. So the crime does not create a problem for performing his job. I think what we were saying earlier is, it really needs to relate to the job. So I would say no, that you wouldn't want to retract the offer there, unless there was something else that maybe relates to the DUI that came up during his interview, that maybe he has timeliness issues, or, I guess I would try to base it on more than just the blanket exclusion. He's got a DUI conviction, even though it doesn't relate to his job.
Yeah, I agree. I would not recommend. I think it puts you at risk.
Yeah. So again, it's like what this person must know is, like, if it creates a problem for performing the job, that would clearly be able to support an exclusion for that person. But if it doesn't, you just need to try to point to some other things if you're wanting to truly exclude this person from the job.
Okay.
I have one other question. Could you talk just to a best practice for how you close the loop with candidates that you've interviewed but have not hired?
And I can definitely handle that one. So back in my HR days, that was one of my responsibilities too, was we would keep a copy of all applications that we had received, and then we would send them just a generic letter, thank you for, applying for this job, and, but we have chosen another candidate, or you don't want to go too far beyond keeping it pretty simple, like, we filled the position, best of luck in your future endeavors, signed so-and-so. But it is good to close that loop, because that way it's just good for the employee or the applicant to know whether they did or didn't get a job. I mean, we've all been applying for jobs, I'm sure, in our careers where you never heard back from that company, and deep inside, well, I guess they didn't want me. But then 3 months later, they may call you, and it's like, okay, I guess that was still open.
So what about, would you recommend then, what if someone's tendency is to say, I feel like something more personal is needed. I'm going to call and let someone know that they're not selected.
Well, first of all, that's a time issue, too. I mean, it's going to take more of your time. It's easier just to populate all these letters and send them out, especially if you're getting a lot of. But if they've gone farther in the interview process.
Our tendencies, if we're in HR, is to be more touchy-feely.
Yeah, right.
And we want the personal touch.
Yeah. So I wouldn't not recommend doing that. I guess just know that it may open you up to more conversation about, why wasn't I? The applicant may just want to talk more about.
That's my concern.
And then you have to try to.
It puts you on the spot, but it also puts you in that circumstance. You need to think carefully about that, because what if now the applicant asks you, well, so was it because of my DUI?
Right.
Or was it because of this?
Right.
And what is your answer going to be?
Right.
As impersonal as Lauren's
original
approach.
It's not me, it's you. No.
Right.
No, it is you.
but as impersonal as that may be, I think, honestly, I think that's the reason you see so many people take that approach, because if you get on the phone or in a personal circumstance with someone, and I mean, that doesn't mean that you're not going to have the occasional person who actually calls and says, I got this letter from you, I want to know why. But, at that point, I strongly recommend not getting into the details, because, we considered all of the different qualifications. We had a lot of good candidates, and we had to pick the one that we felt would be the best fit for our organization or for this job, but steering away from addressing specifics.
And another thing we would also do in HR was we would keep those applications in a file, and we would retain them for at least a year just in case someone ever tried to open up a claim of discrimination based on hiring for that position. That way we could go back and look through,
show that
we based it on, non-discriminatory, reasons that we didn't hire them. Otherwise, you'd be like, oh, we'll have to try to find who applied for that job, and,
Yeah,
I think that's a good point. Show
right.
that you can screen out a bunch of people.
You don't want to shred everything after the minute you hire.
Yeah.
I agree that it's a good idea to hang on to everything related to that hiring at least for a 1-year period. I think at a minimum. Yeah.
Great, very good. Thank you for that. That was the last question. So Ann and Lauren, I want to thank you very much. That was a great interaction. I think you guys should do like a weekly podcast or something. I think that would be very entertaining. You interact very well together. I love it. So for those on the call, when I believe Alicia, our host, when the session ends, there will be a copy of the PDF of the slide deck available for you to download. I think it's coming up on your screen now. And then there will also be a recording of the full session available on our YouTube channel, NCMS Plan. That'll probably be up probably next week sometime, so keep an eye out for that if you want to share the full webinar and audio with anybody else who wasn't able to attend. So again, thank you all for attending today. Thank you, Lauren and Ann. We will have another session probably in about 3 months, so watch for the invitation. Thank you all so much.
Thanks, Gary.
Thank you again to all of our participants for joining us today. This does conclude today's session. You may now disconnect.